and which was heard on 4th of December, my lord. My lord, your lordship had been pleased to direct the matter to appear on 11th of December, my lord. In the order sheet, it is showing, my lord, 11th of January. 11th of January is, my lord, a Sunday, my lord.
To be mentioned, we'll change it. But order sheet has to be changed. We'll keep it in the to be mentioned and make the change.
My lord, tomorrow the award holder is to argue on maintainability of our application, award data's application, my lord.
Has been passed or not passed? This has to be modified then. Whatever it is, we'll tomorrow we'll keep it tomorrow.
My lord, then we'll have the argument on 11th tomorrow, my lord, on maintainability.
Maintainability. When is the matter?
Tomorrow it is supposed to appear, my lord, and the award datas will argue.
Matter be listed tomorrow.
I'm grateful, my lord. Extremely grateful.
Have you need to mention a execution application for withdrawal?
May I be permitted to mention, my lord, this matter?
That's it.
May I be permitted to mention, my lord, for withdrawal, my lord, for withdrawal.
Hey Gopal.
Execution case for withdrawal, my matter has been settled.
कैसे डेट किया है? डेट कैसे गलत लिखा? जनवरी कैसे चला?
Sleep for withdrawal, my lord.
Yes, yes.
Execution matter to be mentioned. Deeply obliged, my lord.
But may I mention
Yes.
the 37 appeal, my lord, your lordship has held that it is maintainable. Lordship has kept it after 2 weeks, my lord, will come to the closer to the vacation, my lord.
So the order has been uploaded.
Yes.
Yes.
We have got the order.
Yes.
But kindly keep it next week, my lord, because it is like an appeal. There is no affidavit necessary. I have enclosed all the records of the.
Let me go. What is the urgency as such?
But urgency is only this, my lord. I am being hauled up in contempt.
Now after this, what?
I will not sleep.
That much you will manage, Mr. Singh. We'll have it in January.
But then kindly fix a date, my lord, in January itself, my lord.
We'll indicate.
Because the arbitration is proceeding. Entire matter is proceeding on prejudice.
You mentioned in first week of January.
May I make this submission? My lord, kindly take it this side of the vacation. Why I'll tell you.
This side of the vacation won't be possible for me. I have a lot of hearing matters going on. Mr. Singh. I won't be able to do it. Your matters are there, couple of them. We have to finish it.
It is more urgent than a 34. But
Yes.
it's an interim application. That is why we are saying.
January 1st.
Because what is, I'll tell you, Lordship, the learned arbitrator.
Nothing is going to happen, Mr.
No, I know nothing is going to happen. But question is, it's a question of prejudice which is working in the mind.
That's all right. We have, to an extent with this order, the prejudice will also go away. We'll have it in that. Let's finish those matters of.
Immediately after reopening in that case, my lord. Let it not appear in the monthly list of January. Otherwise, my lord, again I will have to come and mention.
Let it be listed on 22nd of December. 2
Yes,
weeks is
yes,
20.
It will, let it. Okay.
May I have your lordship's name to mention a section 37, my lord? There's some urgency because I'm being hauled up in the contempt, my lord, for the arbitrator. This was being heard by Honorable Justice Kapoor, where the parties were trying to settle the disputes. Since the settlement has failed, my lord, Honorable Justice Ravi Kapoor has released the matter for being listed before your lordship. This can be listed, your lordship, any day subject to the convention.
Not right now. Not right now. Not before the vacation.
There are contempt proceedings which are going on.
That's all right. Deal with your contempt. Not before vacation. I'm too hard pressed for the matters. You mention in January first week. We'll see it. We'll have it in January.
Please, my lord, may I mention my application seeking stay of the award in an execution that has been filed? My lord, the difficulty...
File it, sir. File it.
My lord, the learned registrar is refusing to issue the master summons on the basis of a hyper-technicality that the notary, which is notarized in Delhi, the notary has not initialed wherever he has affixed his seal.
Whatever it is, I'm not going to interfere in that.
One execution application for listing.
My 29 application, my lord. Well, we prepared a list, my lord, of dates, list of dates which would help, my lord.
Yes, it helps.
The arbitrator was appointed on 17th of May, my lord, 2023. She held her first sitting, my lord, on 13th of June, 2023. And my lord, statement of claim was filed on 11th of July, 2023. And my lord, statement of defense on 23rd of September, 2023. There was once, my lord, an extension under 29A3, which was 30th of August 2023, my lord. Then what that expired on 21st of March 2025. And my lord, prior to that, an extension was passed under a 29A, which was initially filed, my lord, on 3rd of March 2025, which was till 20th of November 2025. Now, my lord, we have it got concluded on 21st of September 2025, but the award is awaited, my lord. So, my lord, we filed this. So, accordingly, lordship, my lord, extends it for 4 months, my lord. I am
Yes, no objection, I guess. Yes, we take down the present application. With the first paragraph, the present application has been filed at the 29A of the application. Learned counsel for the petitioner states that the
affidavit of service or appear kore geche.
that the learned sole arbitrator was appointed by order dated 17/5/2023 to adjudicate upon the dispute between the parties. Full stop. The pleadings were completed on 17/5/2023, with the consent of the parties. The mandate of the arbitral tribunal was extended till. This is extended till.
My lord, this was extended. Yes, my 21st of
21/3/2025. Full stop.
No, mandate would expire, my lord, on 20th of November 2025.
Oh,
20th of November 2025.
20th of November 2025. No, the first with the mutual consent.
Oh, that, my lord, expired on 21st of March
Yes,
2025.
that's what I'm saying. With the consent of the mandate expired. Full stop. Later, by order dated 5/3/2025. No, 30th. The order is of 30th, right? 30th.
No, my lord. The order is of 3rd of March 2025, by which, my lord, mandate was extended for 8 months, my lord.
By order dated later, by order dated 3rd of March 2025, this court extended the mandate of the arbitral tribunal for 8 months till 20th/11/2025. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the petitioner further submits that the final arguments have been concluded on 21/9/2025, and the matter is now pending for publication of the award. Full stop. Upon consideration of the entire record, this court is satisfied that there has been no delay attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceedings and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 4 months from today. Full stop. The learned sole arbitrator is requested to
From the date of
publish the award. Is requested to publish the award within the extended time period. Full stop. With the above observation, the present petition stands disposed of.
Lordship has stated from the date we communicate the order.
From today.
Grateful.
My application under section 29A.
I agree for the statement. There's no objection. Not the hearing has been concluded. Not there's a
it's for
letter not communicated
award
from
is
the
also-
arbitrator annex, not saying that the award is ready, not if a fortnight's time is granted, not the lordship, the arbitrator will.
Page 97, the email by the learned arbitrator.
When was the arbitrator appointed? You just give the date.
Arbitrator was appointed on 17th of February 2023. The order is at page 19 of the application.
17th of February
2023. Thereafter, there has been 3 extensions.
Lord, he's not the substitute arbitrator. My lord, originally, my lord, this was long time back, my lord, long back, my lord. But
Before
finally, my lord, this
20.
arbitrator, my lord, was appointed in February 23. My lord, he has concluded the hearing, my lord, and
When was the first appointment done, sir? I have to record that in the order.
First extension, my lord. First extension.
When was the
originally
arbitrator
appointed.
appointed?
Original appointment was on 17th of February 2023. That is a okay, first appointment was in 6th of January 2015. That is at para 4. That is pleaded at para 4, my lord.
And then
Thereafter, we filed an application under section 4911. The Honorable Court directed to file a section 13 application before the arbitrator, which was never heard. Thereafter, we came up with an application for appointment of arbitrator, and the Honorable Court was pleased to appoint the arbitrator with a order dated 17th of February 2023. That is at page 19. Thereafter, the arbitrator entered reference and it continued. And the first extension was granted by the Honorable Court on 22nd of February 2024. That is at page 21, my lord. Thereafter, there has been 2 extensions. The second extension is at page 23. Video order dated 5th of November 2024. An extension was granted for 6 months. And the third extension was granted on 15th of May 2025, which is at page 25, the order.
for how long?
For 6 months. It was communicated to the learned arbitrator on 21st of May 2025. So it stood extended till 20th of November 2025. My lord, there is a delay. There is a delay in filing the application, which I have pleaded.
Now the delay and all, it doesn't really, after Rohan Builders,
Yes, sir.
the question of delay. Not.
And if my lord comes to
Lord,
page,
finally, after 10 years, my lord, the proceeding, my lord, is coming to an end. My lord, we rather have the award and then decide what we want to do.
All right, take down the present application.
I'm praying for 2 weeks extension.
Learned counsel for the petitioner submits that as per the terms of the contract between the parties, the respondent, vide order dated 6/1/2015, originally appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. However, later the petitioner challenged the mandate of the arbitral tribunal before this court by filing applications under section 14, 15, and 11 of the Arbitration and Conciliation Act 1996. Full stop. This court-wide order dated 17/2/2023 terminated the mandate of the earlier arbitrator and appointed the new arbitrator to resolve the dispute between the parties within a period of 1 year. Full stop. Thereafter, wide order dated 22/2/2024, 5/11/2024, and 15/5/2025 extended the mandate of the arbitrator by 6 months each. The mandate of the arbitral tribunal was extended by 6 months each. Full stop. It is stated that now the mandate of the arbitral tribunal has expired on 21/11/2025. Full stop. Learned counsel for the petitioner further submits that the matter is listed only for publication of the award. Full stop. Hence, he seeks an extension for a period of 2 weeks to enable the arbitrator to publish the award. Full stop. Learned counsel for the respondent states that he has no objection to the said extension and full stop. Upon consideration of the entire record, comma, this court is of the considered opinion that there is no delay, unwarranted or undue delay attributable to the arbitral tribunal. Full stop. To to the sole arbitrator, to the learned sole arbitrator, full stop. Having regard to the advanced stage of the proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 2 weeks.
2 weeks.
2 weeks from today, full stop. The learned, full stop. The learned sole arbitrator is requested to make all reasonable endeavors to publish the award within the extended time period. Full stop. With the above observation, the present petition is disposed of.
Deeply obliged, my lord.
I appear for the petitioner, my lord. They were to file their affidavit and to comply with the order, my lord, dated September 22, 2020.
Ready with the affidavit is not affirmed, my lord. Kindly gives me the today's time, and I'll be able to affirm it and give them an advance copy.
But not so.
There was another, my lord, direction to let them know about the bank account. My lord, paragraph 36 of their application discloses 2 bank accounts, one of the Yes Bank, another of the Kotak Mahindra Bank. I have taken instructions, my lord. The Yes Bank has been freezed due to their letter. And my lord, the Kotak Mahindra Bank, we have no association with this account, my lord.
I think, my lord, my learned friend is mistaken. Kindly seize the order dated September 22, 2025. Direction was to furnish withdrawals, not the bank details.
Well, I cannot provide it.
Lord, the day it was freeze, on that day they have withdrawn 5 lakh rupees. This is the conduct, my lord. From 22nd September 2025 till today, my lord, we are just running after them despite getting an order. They come and take time on all occasions. Kindly seize, the word is very specific. Account shall be rendered. Followed by my lord's last order, my lord, wherein my lord had asked him to comply with the order. And so far as, my lord, freezing is concerned, my lord, freezing does not restricts one to obtain a statement and to furnish the details of withdrawals.
It restricts the
It's only debit freeze.
Well, we cannot obtain the bank statement, and once it
My learned friend is mistaken. Debit freeze means debit freeze.
It's only that you can't operate the account.
You can't withdraw.
No,
That doesn't
not allowed. We are not allowed to even obtain the statements. It says until and unless there's an order from the court, we cannot do that.
What kind of freezing is this that you can't even get the information on?
They have stated to us. We have.
Where is that? Have you written to them in writing?
No, my lord. We have gone to them. We have stated to them. And my lord, the most important thing, why could not we affirm this in this position? Because my lord, the respondent number 4 has been hospitalized. The other
I'm not concerned about that.
For that reason, my lord, also, my lord, we cannot obtain that.
What exactly you are trying to do?
My lord, there are 2 grounds for which I cannot file my affidavit. And my lord cannot specify.
So you want me to issue warrant against your respondents? I'll make them stand here and I'll send them to jail. Take it from me. I can see the conduct.
My lord,
it's very evident.
My lord.
It's extremely evident. We can see that. File it by tomorrow. Learned counsel for the respondent states that the affidavit has not been affirmed. He seeks 1 day accommodation. Let the same be filed by tomorrow.
My lord.
List on Monday.
Grateful, Lord. Well, Lord, Monday, Lord, I have some personal difficulty. Can it be Tuesday?
List on Tuesday.
Grateful, Lord. Lord, may this direction, Lord, with deepest of respect, be peremptory, Lord. Lord, failing which I'll move. Otherwise,
don't worry.
Grateful, Lord.
My lord, in item number 4, my lord, I am appearing on behalf of the respondent in this matter.
Yes.
My lord, this is a section 9 application by my learned senior friend. Now, what has happened, your lordship, the tribunal has already been constituted.
So you go there.
No, I know, my lord, this ploy will be taken. My lord, what will the conduct, my lord, I'll show to your lord.
And then second,
nothing, I'll show to your lordship, my lord. Thereafter, my lord, I'll know, my lord, tribunal, what has been formed, my lord, kindly see, my lord. This application, my lord, what happened, they are admittedly defaulters. Now,
At
my lord,
the outset,
please,
your lordship,
I'm
just
the
two
petitioner,
objection, my
please.
lord. Just two
Yes,
objection.
yes.
At the outset, I just indicate, my lord, first tribunal has been formed, and section, my lord, this is the not the appropriate jurisdiction per se, your lordship, because this is not the 2-1 court, your lordship. The principal court has to be before Alipur court. Now, my lord, if now my learned senior friend.
Well, my lord, that, my lord, if my learned friend takes, my lord, section 11 was the, my lord, first in view of section 42, my lord, I can, my lord, approach before this court only. One. Number
What is
two,
the seat of arbitration? What are the
my lord, for that, my lord, section 11 has already been allowed
Page 139, my lord.
by them at their instance, my lord, the tribunal has assumed jurisdiction, my lord, after we has filed, my lord, the
before the tribunal?
no, kindly, my lord, what happened, my lord, admittedly they are defaulters. Now, my lord, we have issued, my lord, 13-2 notice. They did not take any steps before the tribunal. Now, my lord, after that, my lord, we have taken steps, my lord, for possession notice has been given. Now, my lord, they have come up with an application under section 11 where tribunal has been appointed. Tribunal, my lord, we did not get any notice from the tribunal. We did not get. Now, my lord, once we filed it on 27th, we served it. Now, my lord, on 4th, my lord, they on our mail had sent us the first minutes of the tribunal on 4th of December. My lord, kindly see what is written there.
But Shanak, what is stopping you from going?
No, tribunal is, my lord, we can't, my lord, today is the date before the tribunal. Today is our first appearance. Now, my lord, today we cannot go and file an application under section 17. We will definitely file under section 17, but till that time, the scheduled, my lord, asset has to be, my lord, protected. Till that time, because under section 13 subsection 18 of the SURFACE Act, they can, my lord, statutory bar, they even cannot do. And, my lord, as of today, there is no proceedings before the, my lord, they have not obtained any protection before this, my lord, tribunal against our possession notice. Well, this is their conduct. My lord, since, my lord, the arbitrator is a very senior advocate, I am not, my lord, saying a single word, my lord, the way the proceedings has been conducted. I'm not uttering a single word. Very senior advocate, I'm not saying so. No. My lord, today is the date fixed before the tribunal. Today, my lord, my advocate on record will appear. My lord, today we cannot file an application under section 17. We will today we will pray for time.
There is no bar in filing section 17.
Yes, there is bar.
They have been duly intimated,
No,
that the proceeding is being conducted, and still, my lord, they have filed the section 9 application. Firstly, my lord, there is.
Please. Well, I'll show to your lordship. Kindly see the minutes.
Why should we pass an order right now when the
section 9 postulates three situations before, my lord, appointment, during, and after post award. My lord, this is during.
That's all right, but you have to make up a ground that
definitely we will appear and we will file. Well, till that time we have to be protected. Kindly gives me a 15 days time. We will, in the meantime, we will file and move.
I don't see any ground to really.
Well, that is exactly the ground. And then my lord, since, my lord, he is a very senior advocate, my lord, I'm not, my lord, saying certain things, my lord. But the way, my lord, it has been conducted, my lord, seriously, my lord, raises doubt about that, my lord, about their conduct.
That you can always challenge.
Yes, definitely I will challenge, because this is our first day of appearance. We will definitely, my lord, pray for interim order there. My lord, kindly see, my lord, section 13, subsection 13. Will kindly see of the SURFACE Act.
SURFACE.
Yes.
Kindly see 13, subsection 13.
Yes.
Statutory bar. Therefore, my lord, what I am praying today, as stated by my learned friend, that arbitrary tribunal has been appointed. We have been given to, my lord, a mail has been sent, my lord, day before yesterday. Otherwise, they were, my lord, sitting tight. Now, my lord, what I would be doing today is the date. My advocate will definitely appear today, but we cannot file and move it today itself. kindly gives me, my lord, 15 days time. In the meantime, we will move and my lord, lordship will fix it, my lord, make it peremptory. If I cannot get an interim order before the tribunal, lordship's order will automatically vacate. But as of today, Mr. This is, my lord, a huge, my lord, amount which is, my lord, given on loan.
How much is it? Where is it?
Kindly see, my lord, the
Trying to transfer the property.
1,30,00,000.
Where's the loan document?
That's 50,000.
My lord, agreement, my lord, sanction letter, my
There's
lord,
a loan
is at page
agreement.
21.
Loan agreement. Which
Loan,
page?
yes. It starts from page 23. Lord, kindly see sanction letter at page 21. Amount.
Loan agreement 1311.
Yes, page 23, my lord.
Yes. Yes.
পরেরটায় তো আরবিট্রেটর অ্যাপয়েন্ট হয়নি, পরেরটা তো হয়েছে, দুটোতে দুটো থেকে ওইটা কি আর জুরিসডিকশন অ্যাজিউম করেছে?
হ্যাঁ,
ওটাতেও করেছে। আমাকে তো একটা দিয়েছেন, এইটা আমাকে একটা দিয়েছেন। এখানে উনি একটাতে করছে 736। এই যে দিস ইজ অনলি 736। তো এইটাতে তো করেনি। দুটোতেই কি আরবিট্রেটর অ্যাপয়েন্ট হয়েছে? না, দুটোতে কি অ্যাজিউম করেছে জুরিসডিকশন? $132,50,000. 1,32,50,000.
Yes.
And my lord, page 139 is, my lord, the order dated 22nd September 2025, appointment of arbitrator.
Page 30.
139.
Body. How standing in that
Order was passed on 22nd September 2025.
So why did you move before the arbitrator?
We were coming to know on 4th of December, my lord. This is the screenshot. We have been communicated on 4th of December. My lord, I can show it to you.
Wrongly made submissions, my lord.
We have been communicated on 4th of December.
Kindly take the minutes once.
Yes. Minutes. I've handed over the minutes.
My lord, kindly check the minutes once, your lordship.
No, what have you handed over?
The first minutes of the learned arbitrator, my lord.
Give.
It is not a case that they were not informed.
Yes.
My lord, kindly check.
I'll also show. Yes.
I had issued a notice, my lord. The first paragraph says, I had issued a notice dated 17 November 2025, intimating the first sitting of this arbitration would be held today to the parties whose name have been mentioned in the cause title of such and such. It appears that the learned advocates for the respondent have appeared and have undertaken to file their wakalatnama. A respondent here in this application. That is us. And accordingly, it will be filed on the next date. With regard to the notices issued to the Bajaj, the petitioner hearing, my lord, one of such notices have come back with endorsements insufficient. The other notice, which has been posted for Pune, appears to be still in transit, delivered. However, using the office of the tribunal, the clerk of the thereafter the as usual recordings are made. But it is not a case, my lord. We have seen the physical copies of the documents that was there with the records of the arbitrator, my lord. That it was not received by them, my lord. And also, my lord, the earlier erstwhile advocates who were appearing, my lord, they were present, but they didn't record their names because they had no specific direction from the petitioners, my lord. So this is the situation.
And this is the, my lord, screenshot of the mail on 4th of December. My lord, they somehow, my lord, get hold our email ID and the, my lord, the email ID and the minutes have been, my lord, sent to us. kindly see, my lord, the attachment on the right hand side above, date is given 4th of December. Mail. This is our, my lord, mail of the legal department. My lord, right hand side top, my lord, just before the attachment. And September, they get the first time, my lord, the communication 4th of December. And arbitrator records, one is it in transit and one it is not delivered.
My lord will also appreciate page number
But I will
129.
definitely appear before the tribunal today. There is nothing, my lord, since it has come to know. But today, my lord, it is not possible to, my lord, draft it immediately, to file it immediately. My clients are a company. They have to come, affirm everything. We will definitely, my lord, move before the tribunal, and it is the law. Section 17, we will, but till that time, my lordship would make a limited interim order. By that time, if he cannot, my lord, get that interim order from the tribunal, lordship's order will vacate.
This is something, my lord. My lord kindly appreciates, my lord. This section or 11 application, my lord, was heard, and at the consent of the parties, the learned arbitrator was appointed. Now, it was done way back in 22nd September 2025. Now, have there been any, my lord, any urgency in terms of section 9? They could have approached before your lordship.
Arbitrator has to do his task.
My lord,
Send out a notice.
my lord, since, my lord, it was already appointed at their consent, my lord, the parties were present.
All right, but the arbitral tribunal has to be constituted. He has to send out a notice for the proceedings to start.
My lord, it was done. It was done,
not
my lord.
served.
Yes, my lord, it was done, my lord, but
it was not served to him. He only got to know only on the 4th. The sitting itself record he has not been served. The notice has been
insufficient and in transit.
Yes, absolutely. But my lord,
so he only got to
had
know on
there
the
been
4th.
any urgency, my lord, they should have come, because this was there in their knowledge that arbitrator was appointed. If they wanted an urgent interim order from this honorable court, my lord, their urgency should have been, my lord, in such a manner that they had to approach before your lordship at the very first instance. At this juncture, my lord,
we got information
at
they are
this
trying to create
juncture,
third party, we filed this application under
when,
section
my
9.
lord, at this juncture, when they are aware that the matter is appearing today, instead of filing the section 9 application, they could have easily filed section 17 application. But be that as it may, my lord, what are the grounds of section 9 application? That has to be also, my lord, considered by this honorable court. And my also another preliminary objection was, my lord, that this is not the appropriate court for section 9 application. So, my lord, this is, my lord, now, my lord, whatever falls from your
11/6, it has been appointed here. This will all right. All these issues you can agitate before the arbitrator.
Absolutely, your lordship.
I'll give them a temporary restraint. Allow them to file the application 2 weeks of
But my lord, once the arbitral tribunal is formed, lordship 9(3), my lord, it says that every dispute has to be tried before the arbitrator.
That's what I'm saying. Show me. What are you showing? Read the section.
Arbitration Act.
I can interfere at all stages. Before, between,
pending and post award.
and after award.
9(3), my lord, says once the arbitral tribunal has been constituted, the court shall not entertain any application under section 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17. So, my lord, unless, my lord, I am stressing on this fact, my lord, unless there are circumstances that exist, your lordship. But this application does not, my lord, in any manner whatsoever, my lord, shows that there are circumstances which cannot be tried by the arbitrator, but has to be looked by this honorable court.
কোথায় বলেছি যে আমরা এ করতে পারবো না, বাট ইন্টারেস্ট ক্রিয়েট করছে, বলুন প্যারাগ্রাফ বলুন।
But after 4th, when you got to know, why have you not gone to the tribunal? What were you waiting for?
So we immediately filed this.
But why did you file it here? Why didn't you go to the tribunal?
Tribunal, my lord.
According to you also, you have been...
Tribunal is first date of sitting today.
That's all right. Nobody stops.
No, that is not there, my lord. From Pune, my lord, came and my lord.
No, but why High Court? Why are you filing this here? Section 9. Why didn't you file a 17?
17, yes.
Once you are aware on the 4th also, let us take your assumption and your statement to be true, that on the 4th you were aware. Why didn't you move the tribunal?
That
Tribunal has fixed on to
Why are you coming here?
Today, my lord, tribunal is, my lord, fixed at today.
It doesn't matter. You move an application, the tribunal will fix a date.
That is also.
What are you saying? That the tribunal will not hear you?
That is there, definitely.
So why should I entertain?
Not in view of the urgency pleaded. We have
What
stated.
urgency? I can say that there's no urgency.
No. There is
listed today.
in
You
view
will
of
file an application.
I have also shown you on
Why have you come
the
here?
statutory bar.
Why have you come here?
Here, Milord, I will definitely go before the tribunal. I'll definitely
Why
go.
should we give you an interim order, sir? Please tell me. On the 4th, when you are made aware, then you could have approached the tribunal. Why should I entertain this application? There's no need for me to entertain the application. I can dismiss it on that ground itself. I should not entertain.
That is there, Milord, but kindly see the amount due.
That's all right. You move an application, nobody's stopping you.
Definitely, we will do that.
Rather than coming here, you should have gone before the tribunal.
We will definitely do that. We'll definitely kindly gives me limited, Milord,
I
this
should
protection.
give you any limited
Milord,
protection.
otherwise, Milord, if it is
You move an application today itself. This is just because you want an order from the High Court.
No, that is for protection
only-
only. For protection
You
only.
could have gone to the tribunal on the 4th. You are admitting that you have been
Yes,
given a
fourth,
notice.
Milord, fourth, Milord, on yes.
You are aware. Even if I assume that the first notice which was sent by the tribunal, you didn't receive it. But you yourself are stating that you have got the intimation on the
Yes,
4th of
kindly
December.
comes to Milord, page 20 of the application.
After 4th of December, what were you doing?
No.
Milord kindly also appreciates, Milord.
Kindly comes to page 20 of the application.
Yes.
Kindly see, Milord, we filed it on 27 November. Before, Milord, we received the notice from the
It's all
tribunal.
right. That doesn't help you.
That
Once
is
you are
there.
aware, you should go before the tribunal. Why should I exercise my jurisdiction?
No, definitely, Milord, that is there. Milord, this is, I know, Milord, injunction is a
Sorry?
court of equity, Milord. I know that. But kindly, Milord, appreciate our concern also.
Your concern can be well
Milord,
addressed by the tribunal.
if I may humbly also indicate, Your Lordship, surface proceedings have been initiated.
Lordship would kind enough to, Milord, give me one leave that today, Milord, this will be treated as an application under section 17 and we can move it today itself. Milord, this application itself.
That can
Because by today, it will be impossible by today because we have specific information, Milord, they are going to, Milord, sell out the property.
How is this possible? Your Lordship kindly appreciates.
Even before
My Lord,
the possession.
surface proceedings have been initiated. My original title deeds are with the bank. Already, the deeds are with them. They have already initiated, my Lord, the proceedings. Now, how can I now
one
create
day
third party
nothing is going
interest?
to happen, but yes, this application can be treated as
So that I can,
section
Milord,
17.
and we may be permitted to communicate your Lordship's observation before to the learned arbitrator.
What observation?
This
no
may be,
observation.
my Lord is
I can
disposing
pass
of. Very well,
I can
very
dispose.
well.
Learned counsel for the petitioner states that since the arbitral tribunal has been constituted, he prays for this application under section 9 to be treated as an application under section 17 before the learned sole arbitrator. Full stop. Learned counsel for the petitioner states that this application was filed on. When was this filed? Shanak, when was this filed?
27 November.
On 27th November 2025. Full stop. He states that he has been intimated about the constitution of the arbitral tribunal only
By email.
by email dated 4th of December 2025. Full stop. In view of the said development, counsel for the petitioner states that this application under section 9 can be treated an application under section 17 before the arbitral tribunal. Full stop. This court directs the learned sole arbitrator to treat the present application under section 9 as an application under section 17 and shall pass appropriate orders in accordance with law. With the above direction, the present petition is disposed of.
Grateful, my Lord.
Next, what is next?
736 only. He has not assumed jurisdiction 737.
Yes.
Milord, next matter is also same, but here, Milord, arbitrator has not assumed jurisdiction at all. Kindly see, Milord, the minutes, Milord, the minutes which I have handed.
You have been intimated.
No. No, because the minute
Same,
says
11-6.
AP 736, which is the appointment in earlier matter. Here, Milord, although Milord appointed, but he has not assumed jurisdiction at all. Kindly see the minutes which I have handed over in the last matter.
एक मिनट दिखाना.
736 is Milord pertaining
Anyway,
to
I'm
item
not
number-
going to pass separate orders.
Milord, he has not assumed jurisdiction. I do not know. Nothing is fixed today.
My lord, on the last occasion, both the matters were taken up. My lord. And something, my lord, I have to then check. 2 minutes were, my lord, circulated based on, my lord, 2 applications.
Milord, that is
What
not
is the
required.
arbitrator doing?
My
He's
lord,
recording just one.
One. My lord,
It has
nothing
been appointed in 2 matters.
but my lord, I have to check once. But as per mine, because since I was there present, my lord, physically, in my personal capacity, my lord, I am aware that 2 minutes were circulated, your lordship. I have to also check regarding whether the arbitrator has assumed jurisdiction or not. But I am aware, my lord. 2 separate minutes were made for 2 AP coms, indicating 2, my lord, numbers.
Come back tomorrow.
Well, this matter, my lord, I'll indicate tomorrow.
Let him get instruction. What is he doing?
That's why, Milord, I said, Milord, I do not want to say, Milord, against a very senior member of the bar.
He has been appointed in 2 matters. He's sending out notice for one. I mean, are the clerks drafting the notices?
No, my lord, I believe, my lord, I'll clarify, my lord, tomorrow. There's no, because in my presence, my lord, 2 notices were issued, my lord.
Not today.
Milord,
Only 4, 5 not today.
Milord, the lawyer's communication to the arbitrator, Milord, will suffice. If the order is not uploaded, Milord, by 4:30 today, Milord.
Yes, yes.
Other side is আমি আছি তো there's no
Much
problem,
of,
my lord.
Sure.
I'll be there, my lord. Only, my lord, is passing the order for item number 4, and item number 5 is grateful.
Much of.
Lord, that Asansol Corporation matter, my lord, has passed interim order where after demolition order regularization, Lord, withdrawn, regularized.
Regularized. Your effort. That's good. Thank you.
Grateful, my lord.
Written.
This is my application towards section 9 application. Lord, the award was passed on 27th of October 2025. Lord, that is at page Lord 19. The Lordship will kindly find Lord paragraph 2 and paragraph 4, my Lord, 3 and 4, my Lord, despite services, paper publication, they did not appear. And even my Lord, service of this notice has also been, my Lord, made. Despite that, my Lord, today they are not appearing, my Lord.
My lord, I appear on behalf of the respondent, my lord. I'm sorry for appearing virtually, my lord.
Yes.
I have just been served today, my lord. I was praying whether it can be taken up tomorrow, my lord. The application, I have not yet received the application as well.
Friday.
Grateful, my lord.
Friday, not today.
Lord, may I file the postal receipts because, my Lord, the
See,
notice
on
of
Friday.
very
I'm not passing any order.
Ah,
He's appearing.
yes,
Friday.
I'm appearing, my lord. Grateful.
Yes.
My application for section 9, I am enjoying an interim order.
Yes.
Milord, the issue, Milord, raised, Milord, by them. Milord,
What happened? The arbitrator has not been appointed.
Milord, they had taken the point. Milord, very Milord, it's an arguable case. I'll not say they have no case. Milord, they have taken the point that, look, you have filed a section 66 in NCLT, that is for avoidance of the transaction and the agreement. Here you have asking for specific performance of the agreement by seeking to enforce the same in nature of and claim money. So it can't be done. Of course, my lord, we had argued in the ad interim stage, so did my learned friend. The learned judge considered and despite that passed an interim order. This has to be finally heard. In the meantime, section 11 is pending. Justice Shampa Sarkar has given a final view in a section 11 in a SREI matter because now SREI is no longer Kanoria's. SREI is controlled by NARCEL, 51% private sector bank, 49% private bank. So, my lord, they have considered, so it's a different entity which is now controlling the banks. So she has given a verdict in a SREI matter that these are not the defense not to scuttle the arbitration. So, my lord, ineffective lordship follows the view, fair enough. If lordship wants to scuttle the view, then lordship has to distinguish in somewhere or refer it to some. This is the problematic, and I am also praying. I will be only beseeching. They have given me the reply now because the parties were talking, my lord, for settlement. My lord, I need, my lord, 3 days time to prepare. Keeps it any date next week. I have no difficulty if lordship takes it up, my lord. No difficulty.
No, next week. We'll have it the next week. Learned counsel for the petitioner seeks and is granted. Petitioner seeks and is granted.
Gives me till next Wednesday and keeps it on Thursday. I
Urgency is there.
My lord, I do not. They are suffering, my lord. I as a senior counsel.
We'll have it
In a separate account.
We'll have it in January then.
Keeps it, my lord. Then lordship will extend the interim order till January, whatever date lordship gives. I think it will be sorted out. Lordship will not be bothered.
That's much better. If it's sorted out.
I also told you, now it's controlled by the bank. They will sort out.
Learned counsel for the petitioner seeks and is granted 2 weeks time to file his further time of 2 weeks to file his reply to the affidavit in opposition. The interim order.
It's till 14th. Lordship continues till any time.
Till the 14th.
14th of this month, my lord.
The interim order granted earlier by the order dated
28th of
28th
April.
of April 2025 is further extended for a period of 4 weeks. 4 weeks. List after in January. Just give. Let's give a date in January. Can we have one? 7th of January?
7th of January.
7th.
Grateful. Much obliged. Grateful.
Deeply obliged.
Deeply.
Try to sort it out so that we don't have to.
It should be.
Your Lordship, I am on behalf of the petitioner. We have served the
My lord,
we have served the service in the last week as per my instruction, but the service is not yet been affected. Kindly accommodate for this
on
week.
behalf of respondents myself.
They're there.
And my from petition it appeared that it is barred by limited. My lord, they have received on 7th July, filing 1st December. Already more than 120 days.
Your Lordship,
90
I am
days
not
and 1
briefed
month.
about this matter. Kindly accommodate for
With
this
this
week.
young lawyer, I will not pass it.
Yes, my lord.
Who's your senior?
Mr. Partho Sharuthi Das.
Not maintainable, madam. I'm not. Just because you are appearing, I'm not doing anything. But not today.
Your Lordship, he is unable to come before the Honorable Court. Kindly accommodate for this.
I'm not passing any adverse order. This is not maintainable. Communicate to your senior.
Grateful.
We'll have it. When do you want, sir?
Yes, my lord. This is 7th July, 120 days expiring on 7th November. They have
7th
filed in 1st December, my lord.
7th July communicated, huh?
Yes, my lord.
Filed on 1st December.
For 1st December, my lord. From the
Barred.
website of the High Court, it appeared that 1st December it has been filed.
Barred. We'll have it on Monday.
Monday.
Grateful, my lord.
Grateful.
Thank you.
My lords, I appear on behalf of the petitioner. The present application under Section 34 has been filed challenging the final arbitral award dated 26th August 2025, passed by learned sole arbitrator, passed by learned senior advocate Shokyo Sen, sole arbitrator in that award. The petitioner is aggrieved by the arbitral award, rejecting the counterclaim of the petitioner and awarding in favor of the respondent the sum of rupees 36,50,000 along with interest. My lords, may I go to the facts of the case?
No, this. We'll have it some other time. Not going to decide. Within time, right?
Yes, it's within time.
When do you,
It's within time, madam.
within time?
It's within time.
There was a 33 application filed, that's why it is within time.
The respondent had seek rectification of the award.
Petition in the present petition is the petitioner
But just one small thing, madam.
by way of the present petition.
The arbitral records are not there in the 34. If that can
You
be,
file it.
I'll file it by way of compilation.
File an affidavit. Affidavit in opposition, which they call it
It's
here.
not required, madam. There are only grounds here.
Here, affidavit in opposition is not regarding any grounds. It's basically to file all the, missing documents.
My lord permits, I can file a compilation and that can contain all the documents.
Fine with
This is the trend here. That they file affidavit in opposition with all the missing documents. This is what I have seen. Obviously, you're not filing a reply. There's no question of filing any reply. I'm only looking at the award. So But okay, you can file it by way of compilation.
I'll
That's
just
that's
file
all.
a compilation so that that can be taken.
The petitioner, by way of the present petition, is challenging the arbitral award dated 9/6/2025. Full stop. Learned counsel for the petitioner states that the present petition is within time. Full stop. The same is not disputed by the learned counsel for the respondent. Full stop. Within 90 days or 120 days?
Within 90 days.
Within
Form the 33 order.
That's
The
fine.
order, the award is dated 26th August 25. Man.
That's all right. 26th August.
26th August 2025.
26th August 2025. The way देखा है. Sorry, 26th August 2025. Full stop. Learned counsel for the respondent states that seeks and is granted liberty to file affidavit in opposition. Let the trend be there. Affidavit in opposition within 4 weeks. List after, when do you want?
Any day, my lord, for the,
List
it's a very short matter if it can be taken up for hearing. Any day convenient to the honorable bench, my lord.
Monthly list of January?
If any date is fixed, my lord, instead of monthly list.
Monthly list, monthly. When is the award? It's a 25 award.
I am an MSME, my lord.
MSME?
Work done and over in 2019. Completion certificate
Have you
given.
deposited the amount at all?
My lord,
There's no 36 filed. There's no 36 filed here.
They are not
So
the
this is-
MSME, my lord.
It's a MSME.
As of date, I'm an MSME, my lord.
My lord,
It's not an MSME award.
It's not an MSME.
It is not an MSME award. As of date, I'm an MSME, my lord. I'm a very small contractor. Substantial sums due and payable. Completion certificate accorded to my work. Everything done in 2019. Still, I have not received payment. I have been litigating for the last 1.5, 2 years, my lord.
Done. Monthly list.
Any day, if my lord.
Date won't be possible. Monthly list of January.
Very grateful to your lordship.
Much obliged.
I bring for the response.
Let I was
Yes.
addressing your lordship.
You are right, Mr. Saha.
Yes. Your lordship was, I showed your lordship
We had
the
seen that judgment. We
Yes.
ended on that.
I showed your lordship K. N. Satyapalan.
Yes.
And followed by the Bombay High Court judgment in Suraj Industries.
Yes.
Now, my submission before your lordship was that although these two judgments were cited before the tribunal and is recorded, my lord, as a part of my submissions in the award, there is no attempt to deal with them at all. So, these judgments have been just cleanly glossed over. Now, my lord, so far as these judgments are concerned, it is now, my lord, settled law that, my lord, the tribunal, although, my lord, is not bound, my lord, by to follow, my lord, the substantive provisions of law, except to the extent, my lord, they concern public interest, they are obliged to follow, my lord, precedent law. But it would be absurd to imagine that, my lord, the court is bound by the doctrine of stare decisis, the court is bound by the doctrine of precedence, but a tribunal is not. My lord, that is, my lord, clearly the settled position. So, my lord, the tribunal was obliged to, one, my lord, deal with the judgments, my lord, maybe not agree with them, but deal with the judgments most certainly, and, my lord, to follow precedent law.
Yes.
I shall show you, lordship. Just, my lord, to amplify, my lord, what the law on the subject is now, as to how, my lord, it has prejudiced me. My lord, may I show your lordship now, my lord, the judgment of the Calcutta High Court in the matter of PAM developments, which considered this entire branch of, my lord, law in some detail. Well, I shall, my lord, be very brief. I just want to show your lordship, my lord, the judgment is a very, very elaborate discussion on this subject of, my lord, exclusion clauses. But, my lord, may I just show your lordship as to how the position has been summarized in paragraph 75. My lord, just one paragraph. My lord, the discussion is, my lord, elaborate, but I'll not trouble your lordship with that. On such tests as permissible, the award in the present case could scarcely have been touched. The arbitrator found that it was the appellant who was to blame for the delay in the completion of the work, and the appellant allowed the work to progress beyond the stipulated time and accepted completion thereof. Once a party accepts the belated performance of a reciprocal obligation, the other would be entitled to make a claim for damages, and if the former party is found to be in breach, the prohibitory or no damage clauses in the contract for its benefit may be legitimately interpreted by the arbitrator to lose their applicability during the extended period of the work. If the arbitrator, on his appreciation of the circumstances leading to the extension of the period of completion of work, finds the employer to be in breach, which results in the work not being completed on time, the arbitrator's finding that prohibitory clauses would not apply to the extended period would not be outlandish or per se perverse. Malad, this is Malad, the law summarized by the Calcutta High Court. One more judgment I just wish to Malad show to your lordship. Malad, more Malad for the purpose of showing as to Malad how these clauses are to be interpreted. Malad, that is also a Calcutta High Court judgment. This is reported in 2020. Malad, SCC Online Calcutta 566. Well, there was an accepted matter clause here as well.
Paragraph?
Well, please, Malad, have a look at Malad. May I just go to Malad, paragraph 16. The principle that restrictive clauses should be strictly construed entails, at very least, a construction of the clause by the arbitral tribunal. So, Malad, strict construction and Malad entails Malad, a construction of the clause by the arbitral tribunal. A corollary to the above would be the fundamental principle of the rule of law that a party cannot take advantage of its own wrong. If the employer is responsible for the delay in preventing the completion of the contract within the stipulated time, the contractor cannot be prevented from claiming damages for the additional costs incurred by the contractor for the extended period of time on the bar of an accepted matter. After all, a contract for the extended period of after a contract must be interpreted in a reasonable manner and against competing equities of the conduct of the parties, together with the law, which requires a party to be compensated for loss incurred on account of failure to perform of the other party to the contract. If there is the slightest doubt in apportioning the blame for the delay, an arbitral tribunal should not exclude itself from adjudicating on the application of the prohibitory clauses in the contract. Significantly, the tribunal came to a finding that the above analysis brings out the failures were on part of both sides. Hence, a blanket reliance on accepted matters on this finding was all the more unwarranted. This is all the more relevant when the contract involves the dominant party who is in a position to unilaterally dictate the terms to the other. The inequitable distribution of power in favor of one party and the ability of the other to bargain for a better deal touches upon the public policy of India, as well as the most basic notions of morality or justice, envisaged under Section 34(2)(b) Roman 2 and 3 of the Act. An award which wholly relies on such unreasonable terms in the factual background, well, it cannot be entered. Then, my lord, PAM developments, that is Justice Shonji Banerjee's judgment, is noticed. But, my lord, this is the law. So, my lord, why the reason why I cited, my lord, the Calcutta High Court judgment in spite of Supreme Court on the subject is, my lord, to show that the Calcutta High Court has, my lord, while following the same principle, also held that, my lord, these are clauses which require one strict construction. And, my lord, two is, my lord, you have to deliberate and adjudicate upon these clauses. You can't simply wish them away. Here, your lordship has said simply a reference to 8.3 and that is it. Judgments not considered, clause not interpreted, scope of clause, my lord, no inquiry gone into that. Well, I'll not trouble your lordships with more judgments on this. Well, I'll straight away. Now, my lord, before I come to the claim 3, show your lordship, my lord, what is the current position of law. My lord, may I only show your lordship, my lord, 2 judgments on this. One is OPG power. Or, my lord, may I just show your lordship, my lord, first DMRCL.
OPG is the last one, I think.
Yes. My lord, may I just show your lordship DMRCL only for, my lord, a very short point. And, my lord, that is also only on the question of how, my lord, the court interprets contracts. Now, my lord, the court has a right to, the tribunal has a right to interpret the contract according to its best understanding. But it cannot, my lord, wish away any part or portion of the contract. That is what I'm trying to, my lord, highlight. Well, if lordship will kindly have a look at paragraph 46 of DMRCL.
Yes.
Or yes, paragraph 46. Kindly see the heading.
Interpretation of the term.
This is interpretation of the terminal clause by the tribunal was unreasonable. This is the finding of the court. Why unreasonable? Interference with an arbitral award cannot frustrate the commercial wisdom behind opting for alternate dispute resolution merely because an alternate view exists. However, the interpretation of a contract cannot be unreasonable such that no person of ordinary prudence would take it. The contract, which is the culmination of the parties' agency, should be given full effect. If the interpretation of the terms of the contract as adopted by the tribunal was not even a possible view, the award is perverse. Now, here the relevant clauses set out. I'll just show you, Lordship, the clause 29.5.1. Please see 29.5.1 Roman 1 at paragraph 47. The clause says DMRC is in breach of this agreement and such breach has a material adverse effect on the concessionaire. And what is the ground for termination? DMRC is in breach. DMRC has failed to cure such breach or take effective steps for curing such breach within 90 days. This was the clause. Now, this is what the court proceeds to hold. The tribunal found that since certain defects remained after the cure period, this was indicative of the fact that the defects were not cured and that no effective steps were taken. However, logically, the fact that defects existed at the end of the cure period relates to one aspect of the termination clause, that the defects were not completely cured. It does not explain whether effective steps were taken within the cure period. Effectively, the tribunal considered that in-progress steps that had not yet culminated into completely cured defects were not effective steps to offset termination. This places the two components, that is, curing of defects and taking effective steps to cure the defects, at par, to mean that only the completed curing of defects is relevant. The tribunal fails to explain what amounts to an effective step and how the steps taken by DMRCA were not effective within the meaning of the phrase. Evidently, this could not have been the intention of the parties because they have clearly agreed to include the phrase effective steps. They clearly intended that once a cure notice was served on a party, it would be open to them to either cure defects or initiate effective steps, even if they could not culminate into the completing curing of defects within the cure period. Incremental progress, even if it does not lead to complete cure, is an acceptable course of action to prevent termination according to the 2008 agreement. The tribunal did not appreciate the individual import of the two phrases separately from each other. This was not a matter of mere alternate interpretation of the clause, but an unreasonable and uncalled for interpretation of the clause, which frustrated the very provision and which no reasonable person would have accepted considering the terms of the clause. We must clarify that the tribunal could have still arrived at the conclusions that the steps taken during the cure period were not effective within the meaning of the clause for certain reasons. However, such discussion and reasoning is conspicuously absent. This is only to show to your lordship that the tribunal has an obligation to look into the clause and every facet of the clause and understand it.
Para 51.
Yes. Para 51 also. Issue H framed by the tribunal did the issuance of certificate, certain.
Last line.
How it is answered. That's it.
Given that framing the issue was bound to be answered in
That's it. So, only submission in this regard is the tribunal has a duty to read the contract to construe the clause. There was no attempt to construe the clause. And on construction the clause, one had to perforce come to the conclusion that these were the only facets to which the restrictive covenant on the matter of claim for damage could apply. Notwithstanding the fact that law is that this cannot apply beyond the period of the contract or the term of the contract or when you are guilty of non-performance. That is a separate part of the matter. Now, OPG, I'll just show you, Lordship, brief provisions of OPG once. And we'll conclude my submission on the judgments. Then I'll just address your Lordship briefly on claim 3 and close my arguments. OPG DHO. Paragraph 30, is the discussion on the legal principles. My lord, these are, my lord, regular, my lord, discussions. My lord, what is, my lord, public policy, etc., etc., etc. My lord, please have a look at paragraph 39, my lord, at page 461. My lord, this is a discussion on the provision prior to amendment of 2015. My lord, DDA versus RS Sharma is concerned, discussed. Then, my lord, associated builders is, my lord, at paragraph 41. This is also, my lord, pre-amendment.
Yes.
My lord, if your lordship sees paragraph 41, now, my lord, this is very important. Two-judge bench of this court held that audio alterum partem principle is undoubtedly a fundamental juristic principle in Indian law and is enshrined in section 18 and 34(2)(a)(3) of the 1996 Act. In addition to earlier recognizing principles forming fundamental policy of Indian law, it was held that, well, please note this, disregarding orders of superior courts of India and the binding effect of the judgment of a superior court would also be regarded as contrary to the fundamental policy of Indian law. Well, this position has remained unchanged even after the 2015 amendment. My submission is, my lord, first of all, my lord, no, my lord, reflection on the contract, no attempt to interpret the contract. And secondly, my lord, complete disregard of, my lord, the judgments that were placed before the tribunal. And, my lord, then if your lordship sees, my lord, after this, my lord, Western Gecko is considered and, my lord, then one, finding is based on no evidence. Now, your lordship had seen that, my lord, the tribunal said, obviously this is what has happened. Obviously this is what has to be interviewed. So it's, my lord, a conjecture, a surmise, but not a finding based on evidence. Then your lordship sees, my lord, a tribunal takes into account something irrelevant to the decision which it arrives at. Now, my lord, the tribunal has, my lord, said that, my lord, today you have led evidence to prove your damage, but I find it to be absurd. Then, my lord, it says ignores vital evidence in arriving at its decision. My lord, the chartered accountant certificate, the report, the evidence formula, my lord, none of that is considered. So, my lord, associate builders describing position as it stood, my lord, before amendment, my lord, clearly, my lord, provides as to what is the situation. Then paragraph 53, it lays down the Sangyang principles, my lord, which is post-amendment.
Yes.
Then if your lordship sees, my lord, the Sangyang, my lord, principles are, my lord, set out to an extent in paragraph 54. My lord, please come to, my lord, the portion of Sangyang, my lord, which is in paragraphs 39 and 40 of the Sangyang judgment, which is a part of, my lord, paragraph 54 of this judgment. My lord, that your lordships will find at page 466. My lord, may I just place, my lord, paragraph 39? To elucidate para 42.1 of associated builders, namely, a mere contravention of the substantive law of India by itself is no longer a ground available to set aside an arbitral award. Para 42.2 of associated builders, however, would remain, for if an arbitrator gives no reasons for an award and contravenes section 31(3) of the 1996 Act, that would certainly amount to a patent illegality on the face of the award. Then paragraph 40, the change made in section 28(3) by the Amendment Act really follows what is stated in paragraph 42.3 to 45 in associated builders, namely, that the construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would. In short, that the arbitrator's view is not even a possible view to take. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction. This ground of challenge will now fall within the new ground added under section 34(2)(a). Then paragraph 41, what is important to note is that a decision which is perverse, as understood in paragraphs 31 and 32 of associated builders, while no longer being a ground for challenge under public policy of India, would certainly amount to a patent illegality appearing on the face of the award. Thus, a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. And then your lordship will please have a look at paragraph 69 also, We therefore hold that following the aforesaid authorities that it is in the guise of misinterpretation of the contract and consequent errors of jurisdiction, it is not possible to state that the arbitral award will be beyond the scope of submission to arbitration, if otherwise the aforesaid misinterpretation, which would include going beyond the terms of the contract, could be said to have been fairly comprehended as disputes within the arbitration agreement, or which were referred to a decision of the arbitrators as understood. If the arbitrator is alleged to have wandered outside the contract and dealt with matters not allotted to him, this would be a jurisdictional error which would be corrected on the ground of patent illegality. And the summary here is at paragraph 55. So if your lordship will please see the last 4 lines of paragraph 55 at page 467.
To bring the contraventions.
Yes, my lord. To bring the contravention within the fold of fundamental policy of Indian law, award must contravene all or any of such fundamental principles that provide a basis for administration of justice and enforcement of law in this country. Without intending to exhaustively enumerate instances of such contravention, by way of illustration, it could be said that violation of the principles of natural justice, that would be non-consideration of my arguments, or the judgment cited by me, disregarding orders of superior courts in India or the binding effect of the judgment of superior court, and violating law of India linked to public policy or public interests are considered contravention of the fundamental policy of Indian law. The rest of it, goes on to the basic notions of justice, morality, etc. Repeat the same thing. I'll not trouble your lordship. I am really relying on 3 facets. Arbitrator, reaches conclusions on the basis of surmise and conjectures without considering matters on record or the evidence led by the parties, ignores vital evidence, does not take into account my arguments or submissions or deal with them, which is violation of principles of natural justice, and also does not deal with the judgments I cited, which apart from being violative of principles of natural justice also is failing to follow the precedent law in the country. These are, according to me, grounds for setting aside the award. Now, I shall just address your lordship on the claim 3, which has also been refused. That your lordship will find at page 64 of my application.
Loss of interest in respect of excess recovery and prolonged.
May I just read this, paragraph 3.3, which deals with claim number 3. This claim is on account of loss of interest in respect of excess recovery and prolonged withholding of retention sum in respect of phase 1 of work. So one is excess recovery made from me, and second is retention of the money that you recovered, which you were obliged to pay back to me. Claimant's contention submitted through SOC and rejoinder as well as during presentation. Clause 25 of the SCC, that's Special Conditions of Contract, stipulates for deduction of 10% of the amount due to the contractor from each on-account payment as retention money, so as to maintain a reserve in the hands of the employer equal to 5% of the contract price till the date of issue of taking over certificate. The claimant has submitted that the amount of retention money at 5% of the original contract price of 908.63 crores amounts to rupees 45 crores 43 lakhs 15,500. This was recovered by 13 July 2013 by the respondent against the due amount at 5% on the modified contract value of phase works of 657.95 crores, amounting to 32.90 crores. Pausing for a moment, they are supposed to recover 5% of the contract price as retention money. Originally, the contract price was 908.63 crores. They recovered 45 crores 43 lakhs 15,500 against that. But the contract price was reduced to 657.95 crores, so they were obliged to give back a portion of that money, because now the retention would only be 32.90 crores. Considering their repeated requests, the respondent refunded 10 crores on 28th August 2015. So this money was held on for 2 years. The claimant feels that the retention money amounting to 45 crores 43 lakhs 15,500 recovered by the respondent by 13 July 2013 should have been refunded to them on the stipulated date of issue of taking over certificate for phase 1 of the contract on 9th April 2013, if extension was not necessitated due to reasons beyond their control. Hence, the claimant is entitled to interest on the extra money retained by the respondent. My lord, this has to be read with, my lord, the established fact that, my lord, there was no delay occasioned by, my lord, the claimant in proceeding with the contract work, and the claimant would, my lord, if allowed to proceed with the contract, been able to complete it within the stipulated time. On the claimant's repeated request, my lord, this is Roman 4, the respondent made payment of balance amount of 35 crores on 11th February 2018 upon submission of a bank guarantee. Now, my lord, they accept the fact that, my lord, the contract is proceeding. With due respect, I am entitled to refund. They give me back the money, but they, my lord, insist that I should have to furnish a bank guarantee for the money and also, my lord, pay them interest at 4.5% per annum on my money. I have given them the money. It is my money which they are supposed to refund to me. But, my lord, they agree to give it back only on imposition of, my lord, a condition that you have to pay me 4.5% interest on that money. In view of submissions, the claimant feels that the respondent should pay interest on the amount in following cases. Loss of interest of withholding 45 crores till 11th February 2018. Incurrence of interest at 4.5% on 45 crores with effect from 12th February 2018 to 16th January 2021. Well, this is when the taking of a certificate was formally issued. Loss of interest on 32.89 crores withheld as retention sum beyond 9th April 2013. That is the stipulated date of issue of taking over certificate for phase 1 part of the contract. Loss of interest on 10 crores beyond 9th April 2013. Loss of interest of bank guarantee charges towards retention sum beyond the provisions of the contract agreement. The respondent's contention submitted through CSF and rejoinder, as well as during presentation, is the respondent has submitted that in terms of clause 25 of the special conditions of contract, refund of retention money depends on issuance of actual taking of a certificate. The respondent has pointed out that the claimant himself has agreed to pay 4.5% per annum interest in addition to the submission of bank guarantee for refund of cash retention vide their letters dated 17 July 2017 and 1st September 2017. The respondent has commented that the claimant's act of claiming interest for even prospective tenure of the contract is based on conjecture and has vehemently been denied that the claimant has incurred loss of interest. The tribunal's discussion. Well, a very brief, 4 subparagraph discussions. Strive 8 is discussion and decision after studying the documents on record and listening to both the parties. All members of the tribunal have following points to mention regarding claim number 3. Both the parties have agreed that retention sum of 5% to the contract sum was retained in terms of 25. Well, that is a contractual provision. Initially, retention was to be made. Well, it was paid. The question is, when was it to be given back? Value of contract price of original contract referred to as phase 1 of part work remained at rupees 908.63 crores till approval of variation. Even after the approval of such variation order, the contract was revised and not concluded. Well, I don't understand the meaning of this at all. Well, when there's a variation, then the contract price is revised. Well, when there's revision, you have to automatically give me back the extra retention that you've taken. Then Roman 3. The claimant has accepted that respondent initially refunded 10 crores on account of reduction in the amount of original contract and later converted entire cash retention amount to bank guarantee on mutual consent. Well, I'll just pause here for a moment. When you say that I shall not give you back the money unless you will furnish a bank guarantee for it and pay me interest at 4.5%, is it mutual consent? Well, I'm just referring to these clauses in all insurance contracts where the parties come and say that give me a certificate that you've received payment in full and final satisfaction. Well, the principle of accord and satisfaction has come up with your lordship's court in numerous instances. Your lordships have held that no. Well, it's simply because you've said I receive it in full and final satisfaction does not mean that. The court will have to see whether the circumstances were such that you were compelled to issue this certificate or subscribe to these payment terms. Well, kindly see, here it says on mutual consent, as if the contract is modified. Well, there is no mutual consent here because I have been forced to furnish bank guarantee to you and to pay you interest on my own money because of your imposition. And finally, hence the claimant's claim of loss of interest and its compensation is completely disallowed. Well, again, I would say, very respectfully, that this is, again, bereft of reasons. Now, reasons are my lord, the logical nexus between, my lord, the claim and the conclusions that the tribunal draws for the claim. Dyna Technologies, my lord, then again, my lord, in my lord, I think OPG itself also, my lord, the question has been gone into. My lord, what the court has said, A, there is no reason at all. Then the award must go. B, there is unintelligible reason. Then also the award must go. My lord, this is unintelligible reason. And C, my lord, where there is inadequacy of reasons, then the court has to, my lord, decide as to whether, my lord, the inadequacy of the reason goes to the root of the matter.
Yes.
Now, my lord, here, my lord, my respectful submission is, my lord, this is, my lord, no reason at all, because, my lord, the reasons that have, my lord, been given have been given, my lord, without considering, my lord, the facets of the contract and agreement between the parties which mandated that A, you can only retain 5% of the total contract value as retention. B, you were obliged to give it back, my lord, when, my lord, the taking over certificate is issued. C, the taking over certificate could not be issued within the time stipulated because, my lord, my lord, employer delayed in performance of the work. D, even before the formal issuance of the taking over certificate, considering the progress of the work, they agreed to give me back, my lord, the extra retention money. And, my lord, they, however, made it a condition that you have to, my lord, pay me bank guarantee and give me bank guarantee and, my lord, pay me interest. Well, this was not written anywhere in the contract. It was an unilateral, undue imposition by one party taking advantage of its superior bargaining position. And so, therefore, this is a matter which the tribunal should have delved into. The tribunal has not gone into that at all. Said that this is by mutual consent, which is again, well, the ipse dixit of the tribunal without going into the issue at all. And, well, finally, 5, well, this reason that has been given is, my lord, ultimately, my lord, completely inadequate in the facts of the case and is, my lord, I dare say, unintelligible. My lord, I do not wish to, my lord, side with your lordship, Dyna Technologies and others. My lord,
Dyna,
OPG.
Central Works and...
Yes. My lord, OPG also, my lord, deals with this portion. I should have pointed it out to your lordship, but my lord, paragraph 80. Paragraph 80 deals with, my lord, of OPG, deals with, my lord, this facet. So, my lord, these are my submissions before your lordship. My lord, I have not dealt with, my lord, the argument of my learned friend that, my lord, commercial court, original side, that court. Let my learned friend argue that. I will respond to. Well, I will respond to that finally, my lord, after he finishes the argument.
Yes.
Well, lord, may I have your lordship's leave?
Yes.
May I have
Yes.
your
I'll also take leave, don't worry.
You won't do it today?
No, not ready yet. Tuesday or Wednesday. Sometime next week, my lord. We'll need the weekend, my lord, to.
When have we kept that, those jute matters?
No, that is over. I have filed my note.
You have to file it.
I'll file my notes.
And there's one more which is going on.
No more 34 for me.
No more 34.
I'll be disturbing you with the 37.
Learned counsel for the respondent heard Mr. Learned Senior Counsel, Mr. Jishnu Saha, listed for further hearing of the respondent.
Wednesday, my lord.
Yeah. 16th?
Lordship, I may pray that 15th and 16th, Mr. Saha will not be here.
You're there? You need Mr. Saha?
No, it's all right. It's my duty.
You started the opening rounds also. Because
no,
whatever,
leaving,
I mean, if you have any difficulty, we can keep it after.
17th is okay.
17th.
No, 17th.
17th.
No, not 17th. 15th. 15th is okay. 16th.
Either 16th or 17th.
16th is okay.
16th is okay. We'll have it on the 16th. Yeah, 12, 13, 14, 15, 16. Mr. Banerjee, next is yours, right?
Yes, my lord. This is that matter, my lord, which lordship was hearing, my lord.
So just 1 second, let me call out.
Yes.
So let's pass over item 11. Let's take 12 to 16.
Lordship, I appear for the judgment terms.
12.
I'm for that.
Lordship, I am for the judgment term.
You're for the judgment holder.
Debtor, Your Lordship.
Debtor. Yes, Mr. Ashmi. Item in all the matters?
Yes.
Yes, Your Lordship, 12 to 16.
This matter, my lord.
Yes.
I'm sorry, my lord. May it please your worship. My lord, here we have filed an application before your lordship.
Yes.
My lord, the reason behind the filing application is this. My lord, the award holder, my lord, is a government company.
Yes.
My lord, 2022 first, my lord, we have filed this petition before your lordship, this execution application.
Yes.
My lord, for last 4 years, my lord, the judgment debtors has taken, my lord, this court for a ride, my lord. I'm sorry, my lord, because here, my lord, lordship will find for last 4 years on one instance or other, my lord, my lord, this proceeding has been delayed. And lastly, my lord, the first ballot of witness was produced. Such witness has no knowledge whatsoever. Now the second witness come and my lord, he submitted before this court also that he also is not aware about anything, and that also recorded in my lord, the order. My lord, kindly have a look at my lord, the order dated, my lord, kindly come to page 47. The 2 page I will show, and thereafter I will
Page 47.
The lordship will see, my lord, the case is all of 2021. In 2025, as your lordship got that, in terms of the order, Mr. Such and Such, being the principal officer of the judgment debtor, has filed affidavit. The court finds that affidavit filed by the judgment debtor is not in accordance with 16A of the order such and such, is directed to file fresh affidavit such and such. Now, the second, counsel for the decree holder submits has suppressed several things, and there are several persons involved in the company by an order dated such, this court has directed such and such. If any person have not complied with the order, such and such. Now, my lord, lordship will see the deposition my lord. Kindly have a look at the deposition, my lord, which is at just a moment, my lord. My lord, lordship sees, my lord, just a moment, I just missed the page.
Page 10.
Deposition.
Page 13.
Yes, my lord. Yeah.
Yes. Page 13, 1-3.
26. Page.
Page 1-3, which that
Yes,
deposition.
Page 1-3, my lord.
Question 25, 26.
Well, the court asked him a question. In response to the question, my lord, lordship says here, well, the court asked the question because the witness was not cooperating. No, my lord, lordship says 25 and 26. Who has authorized you to come to court? I went to office. I find such and such in the office, and they have advised me to file this affidavit. Who are Sumit Patra, Vijit De? Sumit Patra are the shareholders. When I left the company, I had given the said company to the said person. What is the residential? I do not know, such and such. Where is the office? Is such. Now, my lord, the thing is, lordship sees, my lord, the order will reveal, my lord, I have disclosed also the list of dates in my pleading. My lord, here lordship will find that one occasion or another, while a witness were produced who know nothing. And the background of the case is unique. Well, from us, they have taken 5 ships. Not a single penny paid. Not a single paid. So entire thing is a fraud and sham thing that has gone. So my lord, today, my lord, I have filed this application before your lordship with prayers. My lord, lordship will find that in master summons. My lord, I have asked them to file, my lord. And the court, my lord, Justice Rao said that you filed an application.
So on the basis of that, my lord, so my lord, we have asked this person who are really behind them to file, my lord, the affidavit, and thereafter they, my lord, be produced before the court so that we can examine. Because the stooges are produced before this court, who has nothing to, they know nothing.
Yes, Miss Rashmi.
Yes, yes. I think there is connection from frozen. The video is frozen.
Yes, respondent. Tell her to come tomorrow. We'll have it tomorrow.
Can it be?
These are all execution matters. Let it be. We'll put execution matters are tomorrow. Let it be tomorrow. You have some difficulty.
In next week,
Then Thursday. Next Thursday. At the request of the learned counsel of the parties, let this matter be listed on Thursday. Next Thursday.
I will personally request him to present personally. I'm grateful. Much appreciated.
12 to 16. 12 to 16.
12 to 16.
12 to 16. All matters.
All. Great.
Lordship, I am appearing for the award holder in this matter. Lordship, on the 26th of November 2025, the award data number 1 was produced. Lordship, and they had undertaken to file their affidavit of assets within 2 weeks. No affidavit of assets have been filed, Lordship. They were represented by their advocates.
We'll issue warrant against.
Lordship.
He had just appeared. It's just like
Yes.
26.
6 November.
Who's the lawyer concerned?
Lordship, there is yes, Shibangi Chattopadhyay.
We'll have it on tomorrow.
Lordship. Lordship.
Tomorrow, not today.
I'll give a notice, Lordship.
Give a notice. Call out the password.
Passover matter. Number 11.
Just give me 5 minutes. I'll be.
Yes, my lord. My lord, on the last occasion, I had shown to my lord that they had requested us, my lord, for taking, my lord, a private siding, railway siding, for, my lord, their business of, my lord, import and export of coal products from different states, interstate, my lord. Now, my lord, apropos that, my lord, I had shown to my lord, after their, my lord, request letter, we formally approved it. So then, my lord, they, my lord, filed a DPR with the, my lord, help of, my lord, liaison and an expert opinion, which, my lord, we had agreed upon. And, my lord, thereafter, my lord, we gave them a approval letter. Now, if your lordship takes, my lord, volume 2, page 245, my lord, this is the letter, my lord, which we give to them on 30th of May 2006. Sorry, it is given by them to us on 30th of May 2006. My lord, kindly sees the letter, the, my lord, contents of the same. We thank you for your cooperation for granting, as I said, my lord, we gave them formal approval of our application for developing a private siding at Durga Chowk at Kharagpur division of Southeastern Railways. Our consultant such and such, my lord, which I showed in the DPR 245, volume 2, have already prepared and submitted 12 copies of the DPR to our office for further approval. Now, my lord, kindly see, in line with the same, we are sending here with our pay order number such and such, dated for a sum of rupees 4,66,551, and then the bank name is given. Now, my lord, just after this, kindly, my lord, looks into the next letter, which is very important, at page 246. Okay. This is given by us, my lord. Lordship will find to them on, my lord, 25th of July 2006. Just after that, your letter dated 22nd of March 2005. The Ministry of Railways hereby grant rail transport clearance to Messrs. Electro Steel for development of siding at Durga Chowk on Southeastern Railway for movement of following volumes. Now, my lord, I already showed to my lord that they projected, my lord, around, my lord, 130, 150 recs per month to us, my lord. Now, my lord, this is the inward movement, my lord, in quantity, my lord, of the iron ore, fines and coal, and the outward movement of the converted product of sponge iron and coke going away from the said siting. Subject to coal linkage, the railway transport clearance is valid subject to following conditions: clearance from Haldia port for use of the siding. There should not be any exchange yard so that trains can be taken right inside the plant's premise and dropped in peripheral yard. The party should, in consultation with the approval of the zonal railway, develop facilities for handling inward and outward traffic. The cost of construction of the railway siding would have to be borne by the party. Now, my lord, what is very important, my lord, is next page 247. My lord, F and H. The party should also develop facilities for loading and unloading on engines on load concept and design yard layouts to facilitate the above. Engine onload would mean loading or unloading in such manner and within such time as would permit clearance of the same wreck by the same engine. Now, my lord, kindly sees H, and I'll show this has never been.
Mr. Banerjee.
Yes, my lord.
So, I don't want to interfere with your
Yes, my lord.
thought and your style of argument, but wouldn't it be better if we go on the award, see the award, and then come back to the documents that how and why whatever has been, presented by you, the arbitrator has.
My lord, why I am showing this is, my lord, the documents before, because I don't have to show all the documents to my lord, is that, my lord, I'll show that
That's all
the
right.
documents, my lord, agreed upon by the parties is contrary to the award. Because the award is not much, my lord. The award is very simple.
Okay.
So that is why I want to show, my lord, the documents and then the award, my lord, because of the simple reason that.
Which context are you showing the document and the?
Well, I'm
how you're
showing that
linking it
I'm
with the-
showing that the award I have attacked, my lord, on the premise that it is completely perverse. because, my lord, it is contrary to the agreement between the parties. And, my lord, the arbitrator has traveled beyond what has been referred to him. And it is against public policy. And, my lord, therefore, my lord, I would show, my lord, that the entire award is vitiated by, my lord, a concept which, my lord, is patently illegal. So, my lord, therefore, I just wanted to show a few documents before I show the award, so that lordship, on the face of it, lordship will understand that, my lord, the award could not have been like this. Now, my lord, just like this second clause that I'm reading in prayer H.
Yes.
My lord, sorry, my lord, clause H. Railway transport clearance, once issued, will be valid for full life of the project if commissioned, or 5 years in case project is not commissioned. Now, my lord, this particular line is so important because, my lord, I would show admittedly there was no commissioning. So if there was no commissioning, my lord, then, my lord, the question is, the tenure of this agreement is for 5 years. And till today, my lord, we are in 2025, and this is a letter of 2006 when they took over the land and, my lord, was to build the siding. Till today, they are in possession of the land. They have not surrendered the land to us. Till today, till the time I'm arguing before, my lord. But compensation has been given, damages has been given, without any adjudication per se, and contrary to the records, my lord, or agreement between the parties. So, my lord, I'm saying the award is not much to be looked into even. Award, my lord, one liner says you are given 74 crores for compensation. But how? How could he come to this conclusion, my lord, with the greatest respect? Because it clearly says that, my lord, either if he commissions, it is for life, and if not commission, it is only for 5 years. So, my lord, I don't have to, my lord, apply much of a mind or evidence to it. I have to just go by the agreement between the parties. So kindly sees, my lord, however, annual report has to be submitted by the company till the project is commissioned, and there is no commissioning. In annual reports are not furnished, RTC will be treated as cancelled. Fresh RTC should be obtained after cancellation, expiry of RTC. Now, my lord, question is that all that the arbitrator needed to look into, my lord, is whether there has been a commissioning or not. And that could have been by a physical inspection also, because lordship knows he is not barred from, my lord, making a physical inspection also. Now, my lord, kindly sees apropos this, my lord, kindly sees, my lord, and our defense may come, my lord, that the commissioning was not held or could not have been done because, my lord, of certain issues. Now, my lord, the fact is that commissioning was never on me. I was to provide them the land for the private siding, and I was to get, my lord, revenue out of the recs, my lord, as freight, and, my lord, a land licensing fees. So all that I needed to do, my lord, is to give them, my lord, the land and